Good evening. Welcome to Left, Right and Centre. I'm Vishnu Shom. On the programme tonight, in a huge victory for the Adani Group, the Supreme Court has said that the report by the OCCRP, which is an organisation funded by the billionaire George Soros, among others, cannot be the basis for doubting the capital markets regulator SEBI's investigation into the Hindenburg case. Delivering the judgment, a Supreme Court bench of Chief Justice Chandrachud and Justices J.B. Pardiwala and Manoj Misra have said that there were no grounds to transfer the probe to a special investigating team. The court has also made several other key observations. Significantly, the court ruled that reliance on newspaper reports and third-party organizations to question the statutory regulator, in other words SEBI, does not inspire confidence. We'll be going through the judgment in the Supreme Court with some of the country's leading lawyers, ex-SEBI officials and market experts. Experts looking very closely at what has happened, where this has all gone and the significance of today's order. But first, this report.
A win for the Adani Group after the Supreme Court refused to transfer the investigation being carried out by market regulator SEBI into Hindenburg researchers' allegations of accounting fraud and shell companies against the Adani Group to a separate special investigating team, saying the power of the court to enter the regulatory domain of SEBI is limited. In a clear verdict, the Supreme Court said, the facts don't warrant the transfer of probe from SEBI. The court backed the panel report that has said there was no price manipulation by the Adani Group and added that newspaper and third-party reports can be inputs but not evidence.
It's a complete exoneration of the Adani Group. The court has said that it trusts SEBI. It does not warrant any CBI or any other police investigation as demanded in the 4 writ petitions, and no other material was found to warrant any other investigation.
Supreme Court has given 3 months for SEBI to conclude investigation into the remaining 2 allegations and take the investigation to their logical conclusion in accordance with law.
The Supreme Court also ordered the government and SEBI to check whether Hindenburg has ignored rules in shorting the market and to take action accordingly. Adani Group Chairman Gautam Adani welcomed the Supreme Court verdict in the Hindenburg row, saying that truth has prevailed and that we are grateful to those who stood by us. In a statement, the Adani Group said that there was an attempt to set a false narrative by a manipulative presentation of matters. Bureau Report, NDTV.
Well, joining us, Jane Gupta, former Executive Director of SEBI, Siddharth Luthra, Senior Advocate in the Supreme Court, Sanjay Singh with us as well, and we'll be joined by Sanjay Asher, the Senior Partner at Crawford, Bailey and Company, in just a few moments. Mr. Gupta, let me come to you first. The larger story as far as the Adani Group is concerned, does this essentially mean that the Adani Group has been given a clean chit in all of the allegations which have been raised in connection with Hindenburg?
See, in an indirect manner, yes. But direct manner, no, because Adani Group was not the person accused or something. It was not a case against Adani Group. So it was something to do with SEBI, something to do all other things. But indirectly, we can conclude that since none of the allegations that were leveled by Hindenburg in its report or OCC are in their report have been found validated by the Honorable Supreme Court, one can safely conclude that nothing wrong has been found to have been done by Adani Group, whether it is case of market manipulation, whether it is case of insider trading, whether it is case of related party transaction or whatever you may say, or even FDI violation. That is one. The second thing that court has said, SEBI has to conclude the other 2 cases within 3 months. There I am a very skeptical, because SEBI, whatever time you may give, is always dependent upon a third party for supplying the information, and that third party is neither under the control of Honorable Supreme Court nor of the SEBI. So that issue will always be remaining unsolved. And then further we can discuss whatever question you ask. Sure. But one can say that as of now, all the allegations have not been proved. And I would say that we did not know the court's requirement for this, because we were all along being aware that what Hindenburg has written was only cut and paste of all the news and information that was available in public domain, and that too half-baked information. All the negatives were pulled together, but positive or arising out of the negative, which were nullifying those negatives, were coolly ignored so as to create a problem.
Siddharth Luthra, there's a lot which has been said in this judgment on the role of SEBI. A key point that has been mentioned is that no valid grounds have been raised in this case so far to direct SEBI to revoke its amendments, in particular FPI and LODR regulations. The regulations do not suffer from any infirmities, and the power of the Supreme Court to enter the regulatory framework of SEBI is limited. In other words, if anybody wanted this to move away from SEBI elsewhere in terms of an investigation, the Supreme Court seems to have suggested no, that you cannot just bypass institutions.
So let's be very clear. In a mechanism where you're dealing with the securities market, we have had SEBI as a regulator since it was created. And that is the body that is tasked under the law to look into securities related issues, including regulatory issues, and can even consider prosecutions can also be launched if necessary. Now, this is the domain by which we operate, and most nations operate on a similar domain jurisdiction where they have regulators oversight carrying out oversight into such matters. The Supreme Court in this case has done three things. One, it is of course accepted that SEBI has a robust regulatory framework. It has said that the suggestions of the committee should be looked into, and that's very important because regulatory frameworks can't be cast in stone. They have to keep getting updated as new ways of business, new technologies come into existence, and therefore it is important for regulations to try and keep pace with technology. They'll never actually keep pace with technology because technology is too fast, but at the same time that attempt must be done constantly. Secondly, the Supreme Court has also accepted that the investigation or inquiry done by SEBI in exercise of its statutory powers into 20 out of the 22 instances or allegations that were made is valid, and therefore the exoneration, if we may call it that, is valid. And on the contrary, it has taken an adverse view of the OCCRP report as also the Hindenburg report, and said that those are based on unfounded information and not substantiated. Thirdly, in the context of PIs, the court has taken a view that media reports should not be relied upon unless they are backed by substance, and therefore the concern that they've raised is that PIL is an important jurisdiction and the petitioners should have had substance in what they were saying, evidence based on the basis of which they wanted the relief that they had claimed, and merely because the petitioners feel that the regulatory mechanism is not adequate or not to their satisfaction is not a ground for the Supreme Court to enter and look at regulations and the efficacy of it based on petitioners' pleadings. The court seems to be satisfied with the regulations as per the directions given. That's the view. And that is where it has closed the matter, apart from a very valid direction, which is to look into investors' grievances, because investors have lost money, and that's a matter of concern.
Okay,
which
I
the court
just
is
interrupting
rightly
because
raised.
you've summarized it as you brilliantly do in court all the time, but I need to discuss each of the points. So let me just go across to Sanjay Ashar. One of the key points which Siddharth Luthra was mentioning is the reliance on a third-party organization report without any verification. The court said you cannot rely upon that as proof. I think it's important to make the point that it's not as if the Supreme Court has said that you cannot refer to third-party information, documents, media reports, etc., etc. The only point that the Supreme Court has said is that you need to verify it, and there has to be a basis in those documents which you are relying on if you are bringing it to the Supreme Court. And in this case, everything that the petitioners appear to have relied on seems to be lacking in merit. Is that essentially the point, Mr. Ashar, that the court was trying to make?
Absolutely. That is exactly the point.
Mr. Ashar, go ahead. Yeah, go ahead, Mr. Ashar. Yeah.
That is exactly the point which Supreme Court has made, that it can't be a conjecture, it can't be hearsay, it can't be some media report on which basis you run to the court and try to snatch some of the other orders. So therefore, there has to be some reliability, some authenticity of the reports or of the point which you are trying to make.
And the other key point, and Sanjay Singh, would you like to come in on this, is that the Supreme Court, if you take a look at the verdict itself, is trying hard to ensure that the interests of small investors who've suffered so much, who've had their investor wealth wiped out when Hindenburg happened, that is protected, and that this judgment isn't just about Hindenburg and Adani, it is about protecting small investors even in the future.
Yeah, that's a very important part, because ultimately it is the small investors and also some big investors, and there was an attempt even to make the institutions like LIC and SBI suffer because political allegations were also made on that count. It was very significant that Supreme Court said inquiry should also be conducted against those institutions which actually made this happen, including Hindenburg. That's a different matter altogether as to how those inquiries can proceed, because Hindenburg is not based out of India and their operations are not here. But that sends a very strong message across. Vishnu, remember, for last 1 year, since January 24th last year, there is a great deal of political controversy over the issue. The opposition parties, Congress in particular, tried to make this as something which would bring the Modi government, potentially impact Modi government very adversely now and in 2024 elections. We have also seen some entities based abroad, like George Soros and OCCRP, which he funds, coming out with another report at a time when G20 was to be held.
Yes.
And at the time when the nation was basking, celebrating landing of satellite on moon. And there was also attempts to say that the LIC's money has vanished and SBI and other public sector banks are going to be in great trouble because of this. Parliament, was stalled last year. Whole budget session was washed out. President's made an address to the Parliament, the new president, President Murmu then she was new president. And Thanksgiving motion was not allowed to be debated. All this, and ultimately it was the investors, small investors who suffered. Also, there was an attempt to put question marks on credibility, on regulatory mechanism and our regulatory institutions. Because if you have to target some nation's interest and business, then you also target those
right.
regulatory
And so, Sanjay, you mentioned lots of points on what took place, inside Parliament, outside Parliament for the best part of the last year. Mr. Gupta, based on what you have read in the Hindenburg report, the OCCRP report, and what the Supreme Court has been looking at, do you believe that there was some sort of a conspiracy, or is that argument that this was a conspiracy too far-fetched?
See, it will be very difficult to say whether there was a conspiracy or not. But when you look at the sequence of event and timing, it very clearly says or means that it was aimed to hurt at the maximum. Hindenburg itself said that its objective was to make money. It was sitting on the information for 6 months, released the report only when the FPO was to be there. When there was a Republic Day, the some guest was coming, then there was a budget. So all that was orchestrated. Now, in normal course, if any intelligent person was to read Hindenburg report, it will very simply conclude that this is a biased report because the writer wants to benefit. Even if I agree that writer wants to benefit, I will still examine it critically. Now, when I examine it critically, somebody sitting in Timbuktu may not know the fact, but somebody sitting in India certainly knows the fact that if Rajesh Adani was arrested by DRI in 2004 or 2006, it was all the way till Supreme Court he was exonerated. So when you do not give the exoneration thing, only give the arrest, that arrest has lost relevance a decade back. But I am harping it today. Now, our intelligent people latched on to that and do restrict, and they orchestrated attack on that. So that very clearly indicates that while the Hindenburg had a motive of making money, the other people who were orchestrating for the Hindenburg report as a gospel truth and Adani chor hai, State Bank डूब जाएगा, LIC डूब जाएगा, they were having a motive which I cannot say what was the motive, what they wanted to achieve, but I can certainly say that their action was not to target or was not resulting in only hurting the people who they wanted to hurt, but they hurt other people also who could have been their supporter. For example, State Bank may have 20 crore, 30 crore customers.
Yeah.
Now, all of them cannot be a voter of our party. So they have hurt those investors. Now, they have hurt the LIC policyholders. But worse than that, the people who did not have patience and they were panicked by this Hindenburg report and fallen share prices, sold the shares at a very low price.
Right.
Now, today the price has come back. Now, who compensates their loss?
No, exactly. And I wanted to just take that question to Siddharth Luthra. Mr. Luthra, that's one of the points which the Supreme Court got into, saying that, if there is anything which has taken place which is in violation of laws by the short sellers, then there needs to be some sort of legal process invoked. What can that legal process actually be? These were people sitting outside our country who published a report. It had an impact on our markets. If there is to be punishment or a process towards that, then how does that begin?
So I would say the first step lies with SEBI looking into those transactions, because that's the market regulator and they have the necessary expertise. At some stage, if SEBI believes that the investigation has to be taken further, if there is, as the previous speaker said, a series of events which constitute or point towards a conspiracy, then that information can be shared with the other investigating agencies of India who do relate and work with agencies overseas and are able to carry out effective investigations overseas with the assistance of their counterparts.
One of the other key points, Sanjay Ashar, if you can come in on this, is that the court reaffirmed the credibility of members in the Supreme Court panel which it had appointed. There were questions raised by the petitioners. A clash of interest argument was raised, I believe, by one of the petitioners as well. Today, the Supreme Court reaffirmed this for the second time in consecutive hearings that the people on that panel who were advising the Supreme Court in this case were kosher. They did nothing wrong. It just seems strange that they were targeted in the first place.
Absolutely. Supreme Court has also given absolute clean chit to the panel as well, or the committee. And they found that the conflict of interest issue which the petitioner raised was absolutely frivolous and vexatious. So, in other words, they did examine everything, and thereafter they've given a clean chit to the committee. And the conflict of interest was only a bogey in my view.
Sanjay Singh, the court also made it clear that just because you want a case transferred from, in this case, SEBI to an SIT or from one agency to another, it's just not something that can happen unless there are extraordinary circumstances. So the court said, and I want you to reflect on this point, such a power is exercised. In other words, the power of transfer, which resides with the courts, is exercised in extraordinary circumstances when the competent authority portrays a glaring, willful and deliberate inaction in carrying out the investigation. The threshold for the transfer of investigation has not been demonstrated to exist. In other words, again, backing SEBI and saying that you can't just go from court to court, investigator to investigator, until you get, a reply or a response that suits your argument.
The Chief Justice, the bench headed by the Chief Justice has made very strong ruling, what you were actually quoting here. The fact remains that in last hearing, if you remember, Supreme Court had come down very strongly, against Prashant Bhushan, the activist lawyer. And thereon, the Supreme Court had practically said similar things, and about the third-party information and his own NGOs being source of information, and for verification, same NGO to be referred, and so on and so forth. The observations and the order, in fact, now they are order of the Supreme Court. They, in fact, the orders and the readings out of those orders, I think, restores popular faith in Indian system. In Indian business, those who are doing legitimate and rightful business, and also the institutions. What Supreme Court has done has actually upheld not just those are matters of legality, but in larger public perception, what Supreme Court has done has far more greater implications than what perhaps may be debated for this particular case. In times to come, the third party intervention, any PIL file for a fishing or roving inquiry to keep the pot boiling, and so on and so forth, those would be challenged if such situations comes, and these orders, the portions of these orders would be referred in the highest court of land.
Siddharth Utra, a final question to you. Is the observation or part of the order of the Supreme Court on public interest jurisprudence, which has been made in connection with this case, something that should apply to the legal system, even going beyond this case? Because they made it quite clear today that, public interest jurisprudence was expanded to secure access to justice and provide ordinary citizens with the opportunity to highlight legitimate causes. Over here, the court seems to suggest that that law, that right, has been misused.
So there are two aspects to this. Way back in 2005, the Supreme Court in Dr. B. Singh's case had said you can't rely only on newspaper reports to invoke PIL jurisdiction. There's a reiteration of that position today. Secondly, the court has always, over the last, I would say about decade, taken a view that the PIL jurisdiction, which had been expanded substantially, is on occasion being abused by persons who may have vested interests, and therefore first they brought in certain rules and regulations as to who can file a PIL, the credibility of the individual and the credibility of the cause. So there has been and there are rules in the Supreme Court now on regulating, and even in the High Courts, on regulating PIL petitions. So there has been a consistent approach of the court to try and ensure that the PIL jurisdiction is exercised only for absolutely legitimate and genuine causes. And I think that's an important part of our jurisprudence. We can't have people invoking the jurisdiction of the court to either halt development projects or even to impact the rights of individuals. At the same time, PIL jurisprudence is important, and the right to access of justice is important to raise legitimate causes where people's fundamental rights, where governance is involved, and where transparency and functionality of institutions is involved.
All right. Thank you very much, all of you, for joining us and for sharing your views on each of the key points which the Supreme Court has ruled on today. We've got several more reactions from leading lawyers and experts from across the country. We'll take a short break, come back with that. Joining us now, Mr. Mukul Rohatgi, for his views on what this actually implies. Thanks very much for being with us. So, sir, let's go through this point by point. Firstly, what has the Supreme Court said which reaffirms the role and significance of SEBI?
The Supreme Court has delivered its judgment on several issues, the most prominent being that the Supreme Court has upheld the integrity of the investigations done by SEBI. The allegations against SEBI having a lackadaisical approach was rejected. The allegation that SEBI should create new policies or new regulations has also been rejected. The Supreme Court has said that SEBI is a body which is functioning well. There is no reason to interfere with what SEBI has done. The Supreme Court has also rejected any request for transfer of investigation from SEBI to either CBI or any other police authority by placing and reposing faith in SEBI. It also recorded that SEBI has conducted investigation in 22 out of 24 cases. Only 2 issues remain for which 3 months' time has been given. The Supreme Court has also rejected allegations of conflict of interest in the committee members, which was headed by Justice Sapre, a retired judge of the Supreme Court. And finally, and most importantly, the Supreme Court has said that you cannot place blind reliance on such kind of reports without any verification, and those reports cannot be preferred over SEBI and SEBI's investigation. So in a nutshell, all the pleas raised by the petitioners against the Adani Group and against SEBI have been categorically rejected.
Mr. Rohtgi, one of the key points which has been mentioned is that the reliance on third-party reports has been rejected, that a third-party organization report without any verification cannot be relied upon as proof. In other words, it's not as if the Supreme Court has said that you can't bring or you cannot refer to third-party allegations, but they have to have a certain basis. But whatever was presented to the court was apparently devoid of that.
See, Vishnu, people have a tendency nowadays to file applications in the Supreme Court, rely upon newspaper reports, rely upon other kinds of reports. So all these reports are unverified. They come from dubious sources, and in this case it was clear that Hindenburg is a self-professed group which believes in short selling, which believes in creating upheavals in a stock market. So, these kind of reports coming from these kind of sources, are doubtful, are shrouded in various doubts, and obviously they cannot be accepted as evidence by a court, especially when you have a robust system of an authority like SEBI, which has done excellent work in the last more than 50 years. So the court was right in saying, and it is a normal practice of the court, that newspaper reports are not relied upon as a rule unless there is proper verification and evidence to support a newspaper report. So that is what the Supreme Court has done, and we have been saying from the beginning that this Hindenburg is a motivated entity which is only interested in making personal profits. It has no respect for any share market, either the investors or the companies contained therein. And therefore, I think this chapter has now come soundly to an end.
Mr. Rohtgi, the Chief Justice, the order said, the Government of India and SEBI need to look into if there was any infraction of law by the Hindenburg report on short selling, and if so, take action in accordance with law. In other words, people who've lost their money as a result of this, there needs to be some sort of justice for them.
Well, I don't think Adani Group can be held responsible for people losing money because the upheaval was created by the report. The report was completely unverified. It's unfortunate that sentiments play a big role in the market, and therefore I must say that the media or the newspapers, electronic or otherwise, should also be a little circumspect in publishing these reports and making it highlights and breaking news, etc., because this really affects the investor and the market. So everybody should be circumspect, and all I can say is that this Adani Group, which has been subjected to all this investigation, has come out unscathed. And one last point I wanted to make was that the expert committee headed by Justice Sapre has made some recommendations. The court has asked the government to look at the recommendations and see whether any systems or regulations of SEBI can be strengthened. That by all means that should be done for whatever they have to do. But this sordid chapter, according to me, should now come to an end.
A final couple of questions. There were, by the petitioners, allegations raised on the credibility of individuals in the Supreme Court appointed panel. The Supreme Court today said that those allegations are dismissed. Could you share your insight into the significance of that observation or that order from the Supreme Court?
See, I find it a normal practice for people who file so-called public interest litigations that they leave no stone unturned in making all kinds of allegations.
Yeah.
So first an allegation was made that SEBI was lackadaisical. The second allegation was that SEBI does not have a sound system. They should be directed to make new policies. The third allegation was against the members of the committee. The members of the committee are handpicked by the court, headed by a retired judge of the Supreme Court. Unless you have some credible material, you can't just go on pointing fingers merely because your allegations have been found to be untrue. This should be a lesson to people who move the court in so-called PILs. And the only thing I would add is that if it had been any other jurisdiction, including a Western country jurisdiction, such kind of claims would have been negated with a huge amount of costs. Now, because costs are not imposed by our judiciary, people take all kinds of liberties in filing all kinds of petitions which take court time, valuable court time. Courts are hard pressed for time. So much time is taken of the committee, of SEBI, of the court, and ultimately people get away just by losing a case and then they go home. So this, I think the court should start imposing heavy costs when it finds that the allegations are frivolous.
A final question. The Chief Justice said, the order said, the power to transfer an investigation must be exercised in exceptional circumstances. Such powers cannot be exercised in the absence of cogent justification. It's almost as if in this case and so many others, if you do not get justice or an answer as a petitioner in one inquiry process, you seek another one till you get something that favors you. But by making a statement like this, is the Supreme Court not reaffirming that essential point that, look, there is a process in place over here. You cannot just ask to go to any judge or any system that suits your merits or your beliefs?
See, the idea is this, that there is already a system in place by SEBI. SEBI is the market regulator to decide all these issues. So you can't just ask for a transfer of investigation to somebody else. Transfer of investigation from the body nominated by law to another body is an exceptional circumstance. Even transfer of police matters to CBI is an exceptional jurisdiction because you have local police in every state. So transfer to CBI is itself an exceptional thing. It's not normal. So here also you ask for transfer from SEBI. SEBI is a specialized body. What is the reason that you should transfer it from SEBI to somebody else? Just because you want to create, some halabaloo and keep stirring the pot, keep the melting pot going on, and you want all these things to be done. The court has reiterated the law that in matters of policy, the court does not interfere unless the policy is capricious or wholly arbitrary. Secondly, the court will not transfer investigation from the authorized body to some other body unless an exceptional case is made out. And in this case, if I may say, no case is made out at all.
All right, sir, quite categorical over there. Thank you very much, sir, for being with us. Thanks very much indeed.
Thank you.
Joining us now for his views on this, Mr. Vayak Chat. Thanks very much, sir, for being with us. Mr. Chatterjee, lots of points mentioned by the report. I'm just going to go through a couple of them. The court has said, and let me just quote what the court has said, we must observe that public interest jurisprudence under Article 32 was expanded by this court to secure access to justice and to provide ordinary citizens with an opportunity to highlight legitimate causes. And therefore it has a particular purpose. However, petitions that lack adequate research and rely on unverified and unrelated material tend to be counterproductive. Is this what ultimately all of these allegations in this case came to? They were counterproductive because they were essentially not verified.
So, Vishnu, thanks for getting me on this subject, because I have studied the case pretty thoroughly. What you mentioned today is right, but it is one of the many moving parts. So if you allow me,
yes, please.
Maybe in 1 minute, I can just tell you the 5 broad principles that the Supreme Court judgment has brought to the fore. May I proceed? So that the viewers have the benefit of simplifying the court judgment. So the first one is that the court very clearly says that it does not want to step into a legitimate jurisdiction of a technical regulator, which in this case is SEBI. And this has come again and again, where if you remember, in the imported coal case with ultra mega power plants, the Supreme Court had sent the matter back to the power sector regulator saying these are technical issues and the Supreme Court should not step into the jurisdiction of an independent regulator. In this case, it happens to be SEBI, unless, and it's an important point the Supreme Court makes, unless the petitioners are able to prove that it violates fundamental rights or any provisions of the Constitution. So therefore, in this case, the Supreme Court is not satisfied that that there are any issues of violation of fundamental rights or constitutional invalidities. So it does not want to step into the realm, into the jurisdiction of an independent regulator. Now, this is a very important point. The second important point it makes is that third-party reports cannot be regarded as conclusive proof. Whether they are independent reports like the OCCRP report or whether they are newspaper reports. Now, it says they can be produced as inputs, but should never be taken as conclusive evidence. Yes. That's bucket number 2. Bucket number 3 is that it does a deep dive on the regulatory structure and the, shall we say, the disclosures required in the FPI regulations, yes, the foreign portfolio investors. Now, it goes into great length. In simple terms, it says that the Supreme Court is satisfied that the way the current disclosure norms are structured with the latest version of the FPI rules, they see no invalidity in that and therefore no constitutional or legal issues, and SEBI can investigate within those, and there is really no opaqueness as has been suggested. The second last bucket, the fourth bucket, is that the Supreme Court in this case does not see the necessity for transferring the case to another investigating authority. It says it is well within its right to do so, provided it is convinced that such a transfer to an independent regulatory authority like the ED or CBI is required. But in this case, it believes that SEBI has enough intellectual capital, legislative powers to investigate in its own right, and therefore will not entertain the idea of transferring to another agency. My last bucket, which is bucket 5, is really a clarification of a few other points made by the petitioners. One, you rightly said, and I'm not going to delve into detail because you've already covered it in your opening remarks, it cautions against the use of public interest litigation with unverified reports. You've already talked about it. Yes. Let me not say it again. It dismisses any hints about the reports emanating in the past on the Directorate of Revenue Intelligence. But let me ask you one point, because we've mentioned this. One key aspect over here, which we haven't discussed as yet, that the Supreme Court says, and I quote, SEBI and the investigative agencies of the government shall probe into whether the loss suffered by Indian investors because of the conduct of Hindenburg Research and any other entities in taking short positions involved any infraction of the law, and if so, suitable action shall be taken. This is huge, so absolutely. Someone has to be accountable. So what you're saying is that any loss to Indian investors because of illegalities in short selling will continue to be investigated by SEBI, and if there are any infirmities found, then action will be taken. That's a very logical stand. And then let me just complete my other point. that the Directorate of Revenue Intelligence letter was completely tangential to the case. It has been settled and had done and dusted, and therefore there was no need to bring it up again. And the allegations, they were in fact said mischievous allegations of conflict of interest among members of the expert committee are unsubstantiated and rejected. That, Vishnu, is the broad theme, the 5 clusters, the broad theme of the Supreme Court judgment. So it sends some very, very important legal, regulatory and constitutional messages. But over to you.
Mr. Chatterjee, one other key point I found really critical. The court said that it was necessary to strengthen the regulatory framework and protect investors and ensure the orderly functioning of the securities market, because at the end of the day, we aren't just talking about the Adani Group. We are talking about millions of small investors in India who've had, in many cases, their life savings wiped out because of a report penned in the United States, which at the end of the day, so many months later, our Supreme Court said essentially doesn't apply. It's to protect investors as well. I think that's a huge signal not just for today but for tomorrow as well.
Yes, you're very right, Vishnu. I mean, this is a different form of aggression against a country, against small investors, where anybody can publish a report either for maligning a group or maligning a country, or out of pure economic interest that it has great pecuniary benefit in short selling because it has taken positions on short selling. So I think the court is correct in its assessment that with this learning, with this lesson, we must safeguard both our nation, our businessmen and developers, as well as the small and not so small investors. It affects everybody, not just small investors. So it is a wake-up call to see what the loopholes are and how they can be plugged.
All right, Mr. Chatterjee, we leave it over there. Thank you very much for joining us and sharing us, your views on the judgment, on the order of the Supreme Court today. Ryan Karanjawala, the senior advocate, joins us at this stage. There are lots of important facets, Mr. Karanjawala, in this order of the Supreme Court. I'm just going to go through a couple of them. One of the points mentioned by the Chief Justice is that reliance on newspaper reports and third-party organizations to question the statutory regulator does not inspire confidence. This is an important point, isn't it? Because so much of the arguments which were mentioned in this case relied on third-party sources which were not verified.
Well, this is certainly one of the factors that the Supreme Court kept in mind when coming to its conclusion. But so before I sort of get into a dialogue with you on this question, there are 2 things I want to point out. First of all, so that it's public knowledge, Adani is a retained client of the firm. However, insofar as this matter is concerned, the firm has not been consulted at all.
Right.
So whatever I speak to you will be what is available in the public domain.
Right. Go ahead, sir. Would you like to add a little bit more to what my question was? And that really had to do with what the observations of the Chief Justice on reliance on newspaper reports and third-party organizations to question SEBI doesn't inspire confidence. This is important, isn't it? Because as I mentioned, so much of everything in this case relied on third parties and which was unverified information.
So that's one aspect of the case. But the real heart of the matter lies somewhere else.
Yes.
It lies in the following things. There were, as far as SEBI was concerned, 24 investigations against the Adani Group, out of which today 22 are completed, and the Adani Group has succeeded in those investigations. SEBI itself, at the end of those investigations, came to the following conclusions. And this has really nothing to do with what is reported in newspapers and otherwise. So the conclusion is dehorse that. The conclusion was and is very clear. One, that the Adani Group did, as far as SEBI is concerned, that the Adani Group did not violate, and no law was violated in the rise of the share prices of the Adani Group. 2, as far as the Adani Group was concerned, no investment laws were violated. 3, as far as the Adani Group is concerned, the requisite information that they gave was adequate and accurate. And 4, again as far as the Adani Group was concerned, they did not violate the minimum public shareholding which was required. These investigations have been concluded by SEBI, and the Supreme Court has chosen not to interfere with these findings. So as far as SEBI is concerned, and in a sense it has also These findings have now received the imprimatur of the Supreme Court because they have declined to interfere in the same. 2 other investigations are pending. Those 2 investigations, when they come to a conclusion, we'll see what SEBI has to say on that. Insofar as there were 3 other challenges as far as the petitioners were concerned. The first challenge the petitioner said was that this should not be investigated by SEBI, but should be investigated by an SIT.
Yes.
The court has declined to interfere and has said no, SEBI is the correct authority to adjudicate. Secondly, what the petitioner said was that there were 2 amendments made, one to the SEBI Foreign Portfolio Regulation of 2014 and the SEBI Listing Obligations and Disclosure Requirements of 2015. The petitioners came to court saying that these amendments were wrong, they should be revoked, and a different law should be put in place. On this again, the Supreme Court has refused to interfere, saying that regulations made by SEBI are a part of delegated legislation and we will not choose to interfere in the same. So this is in a nutshell basically what has happened today. As you rightly said, obviously it's a big relief for the Adani Group and also for their shareholders.
So, the other point, that one of the several other points mentioned by the Supreme Court was this: the government and SEBI need to look into if there was any infraction of law by the Hindenburg report on short selling, and if so, take action in accordance with law. Is this not critical? Shouldn't somebody be punished? You know, for any number of people have lost their money in this entire thing.
So first, while the government will look into it, they'll first have to see whether there's any infraction of law.
Right.
And if there is an infraction of law, is there infraction of the law as is valid in India? And then, of course, the law will follow its own course, and if some wrongdoing has happened, those people will be punished. But that investigation is still to happen.
Right.
Was there an infraction? Was it illegal? And so on.
Another point which I found really important over here is that the petitioners in this case had raised questions on the credibility of some of those in the Supreme Court appointed committee to look into these allegations. And the Supreme Court today made it clear that that was unacceptable.
Well, that's something on which I'm happy personally, because out of those 5 or 6 people on the committee, 2 are personal friends of mine.
And one final question to you. You know, we're talking about, in a sense, the Adani Group because it impacts the Adani Group quite directly. But would you not agree that this is actually about millions of investors in the country and that this verdict has far-reaching ramifications? Small investors need to be protected. You cannot just pull out allegations from somewhere, bring the markets down, affect the company, affect jobs and lifetime savings. Isn't that the larger issue that we are looking at?
So this judgment has an impact at 3 separate levels. One is obviously to the Adani Group itself. Secondly, to the shareholders in the Adani Group. But the third impact is a slightly larger one to the market at large. And the message that goes out is that the market today is large enough and resilient enough to withstand such aberrations. If something goes wrong, it will be rectified, and the system is sufficiently healthy to take care of any aberration of this kind if it happens again. Also, next time round, if a similar report is made about another group, perhaps the reaction of the public at large will be with more cautious.
You know, one final question to you. Again, an important part of this, the Chief Justice saying, before concluding, and this is towards the end of the judgment, public interest jurisprudence was developed to provide access to ordinary citizens. Petitions which lack adequate research and rely on unsubstantiated reports cannot be accepted. Is this not a strong message to the legal fraternity?
Well, what has been reiterated or stated today has largely been the reaction of the courts over a period of time.
Right.
While they have always encouraged public interest litigations, they have always been careful to interfere once they found that the basis of those public interest litigations was not substantial. So in a sense, I think the Chief has only reiterated and the court has only reiterated what has been the prevalent law. It's not something new that has been set out.
Right.
The courts have always been encouraging of PILs, but at the same time have always only been encouraging of bona fide PILs.
Right, right. All right, Mr. Karanjawala, thanks very much, for speaking to us and, sharing your thoughts on this important judgment. Thanks very much indeed, sir.